I don't really see anything loaded, so we'll just start. And this, I believe, is defense's motion. So, Mr. Bruner, you want to go ahead? I did get everybody's briefs, but we'll have brief argument.
Thank you, Your Honor. I'll keep it brief. As you're aware, this motion turns on some video evidence that the defense and the city, the video evidence that captured the alleged assault in this case. And that video evidence was not preserved. The defense position is that evidence is materially exculpatory. The case law on these issues defines evidence as either materially exculpatory or potentially useful. Materially exculpatory evidence need not be a clear indication that the defendant is innocent. State v. Burden is very illustrative on that point. In that case, we were talking, the court was considering a jacket that the defendant was wearing that had cocaine in the pocket, that it resulted in a hung jury at the first trial. So it was not a clear indication that he was innocent, but it was evidence that the jury needed to be able to consider in order for the defense to be able to present their argument. I would point out to the court that the cases State v. U, State v. New, and State v. Lopez Ramirez, those are all unpublished opinions. Defense cited those opinions just to as illustrations of how our courts of appeals have applied the potentially useful category. But the controlling case on what potentially useful evidence is State v. Groth. And I quote, "Potentially useful evidence is evidentiary material of which no more can be said than it could have been subjected to tests, the result of which might have exonerated the defendant." In this case, the city's brief discusses that the officer said that he reviewed the video footage, and there seems to have been a hole in the way of some portion of that footage. However, the police officer's statement in the paragraph immediately preceding that also says that he heard a statement from the victim, and then he viewed the video and believed that the video evidence might have corroborated the victim's statement. So obviously there was enough there that for it to have captured the incident that underlies this case. As for the city's attempt to retrieve the video, the city had means at its disposal to issue an order to preserve the evidence, to seek a warrant to get that evidence. I mean, the hospital's assertion or the police officer's assertion that the hospital just couldn't get it isn't enough. So I submit to the court that the video in this case did capture the alleged incident, and the defense's theory in this case is the alleged incident didn't happen, and that the video would have demonstrated that should we have been able to present that to the court. On those grounds, defense argues that this is materially exculpatory evidence, and therefore the charges need to be dismissed. Pending your questions, Your Honor, that's what I have.
So the officer reviewed the footage, the pole was in the way, and then he said that the video might have corroborated something that he heard from another witness. Is that right?
So, Your Honor, I'll refer you to page 6 of the police report that's attached to my brief. It's on page 15 of my total brief package. But the last paragraph of page 6 is the police officer's rendition of the alleged victim's statement. And then the very last sentence in that paragraph is, "This would later be confirmed via hospital security video." So he's talking about what the alleged victim said happened, and says that it was confirmed by the security video. But then in a following paragraph, the police officer says that he reviewed the footage, and then at some point in the footage there was a pole that obstructed, but it doesn't clearly state what the pole was obstructing or what the officers did see or did not see.
Okay, I'll hear from the city.
Yes, Your Honor, and I will also be brief as I did brief this quite thoroughly. To warrant dismissal, defense both must show that the video had exculpatory value and that the exculpatory value was apparent prior to destruction. Reading State versus Burden, I thought it was quite clear how much it was distinguished from it. State versus Burden was a matter where it was an unlawful possession charge. The defendant's entire argument was that it wasn't his jacket. He didn't not know it had the, I believe, cocaine in it. During the first trial, he presented himself in the jacket. The jury was able to see how the jacket fit on him in terms of him claiming it was not his jacket. That case is very, and the Supreme Court was able to review the entire transcript. They were able to see exactly which way, like how the defense presented it as exculpatory. This differs hugely from that matter. What we have is a description that in the video, you can see the back rear driver door open while the vehicle was parking and a female attempting to go around the vehicle. The video was then obstructed by a pole. There was no showing that defense has made that this video had anything that was exculpatory in it. It was only after the officer reviewed this video that he decided to make the decision to arrest Miss Rayner. The defense asserting that the video contains exculpatory information does not constitute a showing that it does contain exculpatory information. All the information we have available to us is that the video had no exculpatory value whatsoever. And in fact, the city does posit that this video has inculpatory value, as it does align with both witnesses' recounting of how this situation began. Even if the court was to find that this video has exculpatory value, just based on defense's position that it does, even though we don't have any evidence that it does, the city would state that that exculpatory value does have to be apparent prior to the destruction of the footage. Once again, state versus Burden, there was a hung jury. The jacket was stored alongside with other evidence at the, I believe, city clerk's office, and all the evidence went missing. At that point, they'd already went to trial once. They already knew that the defense rested upon the fit of the jacket. There's no indication that there was any sort of exculpatory value prior to the destruction of this video. Defense right now is saying that it did capture the supposed incident and showed that nothing actually occurred, even though that does not reflect any of the evidence we have available to us. But defense saying that that's the case now does not make it that we had available to us at the time that the information was destroyed, I believe 30 days after it was captured. So that would have been the end of May. The city would ask the court to deny defense's motion based on a failure to, first of all, prove that there was prejudicial government misconduct or arbitrary action per CRRLJ 8.3b. There needs to first be a finding of that. In the party seeking relief, there's a burden of showing misconduct. The city did not see any briefing establishing any sort of misconduct. The city also asked the court to deny this motion on the basis that there's no showing from defense that the security video was material exculpatory evidence. Thank you, Your Honor.
A rebuttal.
Thank you, Your Honor. And I don't have a lot in rebuttal, Your Honor. I think it's clear that the police report indicates that the officer did review the footage. The officer claims that the footage showed the alleged incident. The officer even claims to have attempted to gain or gather the alleged evidence because he thought it was important to the case. But then after he was told that he couldn't get it, he just stopped there. And so if Your Honor is inclined to or is leaning towards denying my motion, I would consider the court consider an evidentiary hearing where we could bring the police officer in, and he could be questioned about the exact nature of the video, what he saw, what he didn't see, what the video showed, because his report isn't very clear on that issue. And I think an evidentiary hearing might solve any issues if the court is not already convinced to dismiss.
All right. I'm going to take a brief recess and I'll be right back.
Yes, Your Honor.
Thank you, Your Honor.
And according to Rule 8.3, we're back on the Rayner matter. I'll just read the rule into the record. 8.3, dismissal. 8.3b states on motion of the court. The court, in furtherance of justice after notice and hearing, which there have been, may dismiss any criminal prosecution due to arbitrary action or governmental misconduct when there has been prejudice to the rights of the accused, which materially affect the accused rights to a fair trial. The court shall set forth its reasons in a written order. So reasons for dismissal in a written order. Excuse me. Here, the court does not feel that defense has met its burden to show that the government action was prejudicial or that there was misconduct. I just don't see that from the brief that defense has written, and it was not asserted here in argument today. That's the first hurdle that needs to that we need to hit in order for there to be a dismissal. Beyond that, the video in question, that exculpatory value was not apparent prior to its destruction. I just did not hear any evidence or any testimony that the value was exculpatory. In fact, the court heard from the prosecution that the value might have even been inculpatory. But the court is basing its decision from the lack of the fact of prejudicial government misconduct. So I am denying defense motion for dismissal. Anything else?
Yes, Your Honor, we also have a EHM violation report to address.
I'll hear from the city.
Yes, Your Honor. On January 4th, 2023, Court Compliance Officer Daisy Lomelli filed a EHM violation report, which states that she noticed that on December 25th, 2022, Missy Rayner had a positive breath alcohol concentration of 0.049 at 7:32 a.m. On the 28th, she had a positive breath test of 0.043 at 6:26 a.m., a 0.02 at 7:31 a.m., and then this test. Ms. Lomelli also noted on December 29th, 2022, a positive breath test of 0.088 at 4:18 a.m. and missed tests the rest of the day. Additionally, on December 30th, 2023, January 1st and January 2nd, Ms. Rayner had 3 missed tests required for the SoberLink alcohol monitoring device.
Yeah, I don't have the fucking tube, okay? So
Ms. Rayner, please don't talk.
Officer Lomelli notes that normally they would call and have the individual come in for a urine sample, but Ms. Rayner currently resides out of state, so that's not possible. This is a violation of the condition.
who fucking called me? Huh? You
And-
tell me.
Okay, Miss,
Who
hold on a
fucking
second.
called me?
Miss Rayner, number one,
No, I'm suing all of you. Okay, I didn't do shit. You just wait. Your fucking day is coming. Your fucking
Your client's out of order, Mr. Bruner.
Yes, Your Honor.
Ms. Hanson, please continue.
This is a violation of a condition of release, and as such would be a reason for the city to ask for revocation of release. However, the city is willing to give Ms. Raynor one last chance to instead enroll in an alcohol monitoring program out of Texas so she can be properly monitored and provide those UA follow-ups. There was a danger of violent crime that was present for the imposition of this specific condition of release, as there is a nexus between alcohol usage and the assault that occurred in this underlying matter. So that would be the city's request. I did upload an order on motion, putting that request into writing.
Okay, one moment. And I'll hear from Mr. Bruner.
And Your Honor, at this time, I think I'm going to enter a denial of those allegations and request a short continuance, perhaps a week, so I can have a chance to discuss these issues with my client.
Did you see the reports from probation counsel?
I do have them, Your Honor.
And you are denying them?
Your Honor, the issue I have at the moment is I have not had time to sufficiently discuss those issues, those allegations with my client. In other courts, the procedure that I have used in order to address issues like this is to enter a denial up front and then request a continuance. If this court would prefer that I just request a continuance, that I have some time to discuss these issues with my client. However the court would like to handle that, but I would like a little time to discuss these allegations with my client.
Okay, how much time are you looking for?
Your Honor, I'm going to ask for whatever works for the court, maybe the next hearing that's available for the court, if you've got something available the next couple of days, or perhaps a short set for a week out, something of that nature, so I have more time to talk to my client about this.
I'll hear from the city.
And Your Honor, there's that very full one on the 24th, which I believe you indicated actually might be full. After that, I believe the next Zoom hearing is February 21st. I don't think there is anything in between those two dates. Would it be possible to set to that 24th date? I know it's full, but the city does have concerns about a violation of petition of release.
Understood.
And Your Honor, I think, well, I'm not sure what happened, but I do believe my client is no longer present. So I don't know if she was having technological issues.
She's having other issues besides technological. So, just one moment. I lost my reports. So I know it's full. I know it's full. Okay. No, I'm making that decision. So we will have it, is that the 21st?
The 24th.
Okay, can you vote? Or we can just put it on the order on motion then? Okay. Is there a Zoom? Okay, yeah, there is. Okay.
And for the record, Speedy is currently sent out to April 17th, 2023, so there shouldn't be an issue just sending this over 1 week.
We're setting for pre-trial January 24th. Well, isn't this the defense's? Oh, well, this is defense's motion to continue.
And Your Honor, I can maybe put language that defense
Okay.
not stipulating at this time, setting over.
Okay, sounds good.
If defense has no objection.
No, that's fine. Thank you.
And I signed that document. Oh, yeah, I've saved and signed.
Okay, And is that language sufficient for Mr. Bruner?
Oh,
Mr.
understood. Yeah, I see it, Your Honor. Yeah, that's fine, Your Honor. That language is good.
All right.
I will put in my name and sign. Okay, and I've signed that document, Your Honor.
And you will alert your client as to the date and time.
Yes, Your Honor.
Please admonish her to have a correct courtroom decorum.
Yes, Your Honor.
All right, is there anything else in this matter?
Nothing from defense, Your Honor.
Okay, we'll see everybody back on the 24th. Yeah. All right.
Thank you, Your Honor.